Welcome in. If you're a focus learner trying to navigate the highly bureaucratic, hyper-localized court systems of Washington state, well, you've definitely come to the right place. Think of this explainer as your ultimate guidebook. We're going to decode Washington's complex county court record system together, basically translating a totally fragmented landscape into a clear, usable map. By the time we wrap up, you'll know exactly where to look, what rules apply, and how to access the documents you need without getting completely lost in the bureaucracy.
Okay, let's dive into our agenda for this explainer. We'll start by mapping the court records maze. Then we'll break down superior versus district courts. Third, navigating digital search portals. Fourth, fees and confidentiality rules. And finally, we'll look at the water rights exception.
All right, part one, the court records maze and navigating those local courts.
So, navigating public records at the county level is rarely a straight line, right? It's much more like a maze where opening the wrong door just leads to a dead end. If you've ever tried to pull a basic public record, you've probably asked yourself, why on earth is it so hard to find a simple court document? Well, the answer lies in the fact that these systems are completely decentralized. There is no magical single search bar for everything. Records are divided by jurisdiction, separated by digital and physical barriers, and governed by this massive web of localized rules and retention schedules.
Moving on to Section 2, superior versus district courts, and that tricky jurisdictional split.
To actually make sense of this maze, we've got to clear our absolute biggest hurdle first, which is the jurisdictional split. Because if you don't know which court actually has your record, well, your search is pretty much over before it begins. Superior courts handle the heavy hitters, things like felonies, family law, probate, and civil actions with disputes over $35,000. District courts, on the flip side, are courts of limited jurisdiction. They handle misdemeanors, traffic infractions, and small claims under $10,000. It is a really stark dichotomy. To give you an idea of just how separate these worlds are, in Whatcom County, these two courts literally sit on entirely different floors of the courthouse, with completely different clerks and entirely separate filing systems.
But regardless of which floor you're on, you do have foundational legal rights. Washington State Supreme Court General Rule 31, or GR 31 for short, establishes your baseline right of public access to court case records. Basically, this rule means that documents relating to active or resolved litigation are generally open for you to view.
Now, what's really interesting here is a crucial contrast that actually causes a ton of confusion. General Rule 31.1 governs administrative court records. So if you want a case file, you use GR 31. But if you want to see how the court manages its budget, its personnel, or its internal supervision, you're looking for an administrative record under GR 31.1. They are completely different tracks requiring entirely different request forms.
Let's move into Section 3, navigating digital search portals to actually track down these case files.
So, how do we physically find these files online? Well, depending on the court, your digital experience is going to be radically different. For superior courts, you'll probably use the Odyssey portal. You can search anonymously to see basic case metadata and docket entries for free. But if you want to open the actual PDF document itself, you hit a hard paywall. Conversely, for district courts, you use a system called ResearchWA. On there, you create a free public account, and you can actually download non-restricted e-file documents directly to your device for absolutely no charge. It's a night and day difference.
Let's see how this builds, because there is a really brilliant local life hack to get around this. If you're researching superior court files and you smash into that Odyssey paywall, there's a workaround. In Whatcom County, for example, you can just visit the physical courthouse. Down in the basement, the county law library maintains dedicated public kiosks. Using those physical terminals, you can view the actual digitized superior court documents filed from the year 2000 to the present, totally for free.
Section 4, fees and confidentiality rules. Basically, the financial and legal hurdles you'll face.
But what if you can't visit in person, or you really need certified hard copies? This introduces the financial obstacles in our maze. Public records are rarely free when court staff actually have to do the work. Whether you're looking in Lewis, Benton, or Whatcom counties, standard fees apply. Electronic and physical copies generally run between 25 and 50 cents per page. Need a certified copy? That'll typically run you $5 for the first page. If the clerk has to research the archive for you, expect to pay a statutory research fee of $20 to $30 an hour. Audio recordings of hearings? Usually $20 to $25. And keep in mind, counties often use third-party portals like NCourt for digital payments, and those come with their own extra processing fees.
So the crucial point to remember here is that not all records exist forever, and not all records belong to the public. Things like police reports, court-sealed files, and mental illness commitments are strictly restricted. Plus, courts follow really rigorous retention schedules. A closed traffic infraction might be actively destroyed after just 3 years, whereas a driving while intoxicated case or domestic violence case is kept for 10 years. If you search too late, the record is legally gone. Poof.
Now, let's quickly look at exactly why that Superior Court Odyssey portal has a paywall in the very first place. To get remote document access, law firms and agencies actually have to sign a binding legal covenant called the Odyssey Confidentiality Agreement. They also pay a tiered annual subscription fee ranging anywhere from $250 to $900 depending on the firm's size. They have to sign this because the database contains highly sensitive personal data that was filed way before modern privacy rules, known as GR22, were enacted. The court tightly guards this remote access to prevent private data from being blasted out and redistributed.
Finally, Section 5, the water rights exception, looking at massive public interest cases. Sometimes the case is so massive and carries such vast public interest that the entire bureaucratic system just has to adapt. Meet the WRA-1 Nooksack Basin Adjudication. Initiated by the Department of Ecology, this is a monumental Whatcom County Superior Court case designed to inventory and prioritize water use rights across an entire watershed. Because this litigation affects literally thousands of local property owners, standard document paywalls have been completely dropped to ensure the public can actually participate. $25. That is the flat statutory filing fee set by the state for a property owner to submit a water claim in this specialized adjudication. It's just a localized, highly specific fee for an incredibly complex legal procedure. And property owners now have until June 1st, 2027 to act. This is the extended deadline recently granted by the presiding jurist, Judge Freeman, for folks to get their claims submitted to the Superior Court. And this brilliantly illustrates how courts can use technology to actually help citizens, rather than just block them with red tape. To manage this huge influx, the court deployed a guide and file application. Instead of having to draft complex legal pleadings from scratch, self-represented property owners simply launch the app, answer a series of plain language interview questions, and the software automatically generates a legally compliant water claim. Then they can just submit it digitally or physically to the clerk. It's a real game changer.
Furthermore, for this specific case, true transparency is the norm. The Whatcom County Superior Court bypasses the expensive Odyssey portal entirely. Instead, the clerk maintains a dedicated public webpage where they post free monthly updates of the docket, every major ruling is a free PDF, and even archived Zoom recordings of pivotal status hearings. It's just an incredible exception to the standard rules of access we talked about earlier.
Which leaves us with this final thought. We've navigated the different courts, those complex digital portals, the strict retention schedules, and some innovative exceptions. But looking at the system as a whole, it really begs a massive question. How do we balance government transparency and open public access with the very real need for personal privacy in the digital age? It's a delicate trade-off for sure, and one the court system is constantly trying to refine. Thank you so much for joining me on this explainer, and I really hope this guidebook helps you successfully navigate the maze.